Let's welcome Tracy.
Good morning. Are we ready to go or?
Yep, ready.
Yeah, okay, so I'm tall, so I'm assuming everybody can hear me. Yeah. No, you cannot?
You can hold it.
Should I hold it?
Hold it.
How's this? Is this better? Okay. I spoke here about a year ago on revocable living trusts or living trusts and why everybody really should consider having one. And I'm going to be speaking August 24th again for, I think, an hour-long seminar on the same topic. It's something that I focus mostly, my law practice is mostly about helping people stay out of the probate court. I do a lot of revocable living trusts, but we also do a lot of probate work in trust administrations. One of the things that seems to have developed in our law practice is doing basically unlawful detainer work, landlord tenant law, and real estate law. I was a realtor for 7 years, so I'm privileged to be here standing in front of colleagues because I used to do what you're doing and absolutely love it. I love anything real estate related, and it seems like my experience or what I deal with the most is title officers, realtors, trying to help with emergencies when you guys sell a piece of property. And there's an emergency, whether it's a title issue or a probate, we try to get things fixed and resolved. So I thought we would talk a little bit today on a real quick overview of landlord tenant law. It's probably stuff you guys know, but some of it will deal with unlawful detainer work or what you have to do when you have a tenant that won't be moving out. Some of the things we're going to talk about are leases, overview of the eviction process, notices to terminate. We'll kind of talk about unlawful detainer and the default process and lockout. A lease or rental agreement is a legally binding contract between an owner, which is a lessor, landlord, and a tenant, a lessee, where a tenant has possession and use in exchange for renter services. Usually a document is needed for a lease. Most landlords and tenants want to have your CAR form signed, and that's typically what we do use. There are different types of leasehold estates. There's an estate for years, a tenancy at will, a tenancy at sufferance, and a periodic tenancy. Please excuse me because my secretary did this and I'm going to kill her because I hate this. But I'm going to get these all up here so that you could see this. An estate for years is a tenancy for years or tenancy for years or a lease. This is typically what we use. It's usually a fixed term. We all like people to come in for a year, 2 years, sign leases for 3 years. An estate from period to period is usually your month-to-month type of lease. It's a periodic tenancy. You're not sure when it ends because either the landlord can give notice or the tenant can give notice. You're going to pay month rent to rent, and you can leave pretty much when you give 30 days notice. An estate at will is when a tenant occupies a property with the consent of the owner but without an agreement that specifies a definite rental period or the regular payment of rent. It's really not used in California. In California, you usually want to meet the statute of frauds. And I'll talk about that. Estate at sufferance is an agreement in which a property renter is permitted to live in a property after a lease term is expired, but before the landlord demands the tenant vacate the property. That's a typical month-to-month. Usually you'll have a lease for a year, 2 years, and then it'll default into a month-to-month if you don't extend your lease. Let's get this all up there. There we go. Valid lease requirements. It needs to be written if it's more than a year. You've got to be able to meet what's called the statute of frauds. And that's a legal term, and it would be enforced in a court of law. If you don't meet those terms, then you're really going to be defaulting to what's called a month-to-month tenancy. And some of this, the relevance of this may have to do with a tenant defaulting and you wanting to collect rent, you wanting to collect back rent, or the fact that you are going to end up in court trying to collect what the lease terms were agreed upon. It has to have the names of the lessor and the lessee. It has to adequately describe the property. It has to show the amount of rent and how it's going to be paid. It's got to give the lease term, beginning and end. Has to be signed by the lessor. It has to involve capable parties, meaning everybody has to have mental capacity. You've got to be able to enter into an agreement. And then there should be a renewal provision, if there is one, in boldface print. Obviously, you guys probably use mostly your car forms, so you'll be familiar with all that. The maximum duration of an urban property for a lease is 99 years, and for an agricultural land, it's 51 years. Let me get this up there. A residential rental agreement will address issues such as utilities, maintenance, tenant improvements, use of the property, what it's going to be used for, what it cannot be used for, what the tenant's not allowed to use the property for, the maximum number of occupants, security and damage deposits, and property taxes and insurance. Amazingly, these issues, these things seem quite simple, and they really are, because you have a form that you're able to use, and it has all the things that all of the lawyers and all individuals in real estate have thought about over the years, meaning that they've either had to be in court, they've been sued, or they've had to sue over specific issues with regards to leases. When you have a lease and you have these terms, none of it becomes relevant until you find yourself in a court of law, and then all of a sudden you're scouring that lease agreement, making sure that those terms are applicable, or that there's conditions upon breach of contract. One more, rules regarding pets, guests, parking, and anything else of importance. Security deposits. Your total security limit is, for an unfurnished property, is 2 months. That's how much you can collect. For a furnished property, it's 3 months. Legal deposits, including a waterbed or insurance, or pets, deposits, keys, and door openers. You can get extra money for your deposit if you have pets. And waterbeds, I don't think anybody of you use waterbeds anymore. I'm not sure about that, but Tempur-Pedics now. Any unused part of a deposit has to be returned, and if you have to clean a piece of property, you need to give an accounting of the deposit that wasn't used. So you'll have to return any of the deposit that wasn't used and then give an accounting to the tenant. Interestingly enough, that can be a sticking point between landlords and tenants. It tends to be something where they argue about should this have been cleaned? Was this truly dirty? Was this just use? Was the carpet damaged? Or was it just the fact that the tenant lived there for a number of years? So the deposits can be, whether it's returned or the amount that's returned tends to be quite an issue. I've actually had litigation over this before. It's kind of ridiculous. Oh, there we go. Types of leases. You have a gross lease, a net lease, a percentage lease, and a fixed lease. Whoops, excuse me. I'm sorry about that. Let's go back. A gross lease is, I think, what's most common. It's the landlord pays operating expenses. They pay taxes, insurance, and maintenance. What the tenant pays is the monthly rent. You have a triple net or a net lease where the tenant pays the taxes, insurance, and maintenance, and I think that's more in a commercial type situation. You have a percentage lease where the tenant pays rent based on tenant's gross income. I've not seen that or done that, but maybe you guys have. You have a fixed lease, which is a month to month. Tenant pays a fixed rent amount every month. That's very standard. And then a graduated lease where a tenant pays a fixed rent amount for the period with periodic rent increases at specific times. That's also usually part of your commercial type leases where when a lease term's over, you end up getting a step up in your lease terms. The landlord's duties and rights. He's got to keep the property habitable periodically, and he's allowed to periodically inspect the premises. I typically tell my clients that you should inspect a premises, I think, once every 6 months. You have to give 6 months notice or 24 hours notice. But I've seen situations where if you don't inspect a property at least once every 6 months, maybe you want to inspect the property once a year, you would not believe what could happen inside of a property. And you want to be able to stop that kind of bleeding. So I really think every 6 months a piece of property, there should be 24 hours notice, and you should go in and be able to inspect the property to make sure it looks okay. The landlord has to insure outside of the living quarters, meaning there's got to be insurance for errors and omission insurance in case there's a slip and a fall, liability insurance. There's got to be quiet use and enjoyment of the property. The tenant has to be able to live there in peace. And obviously, you have to have no discrimination by all subordinates. Unlawful acts by a landlord would be a tenant lockout, seizure of the tenant property for improper reasons, removal of doors and windows, shutting off utility services, causing uninhabitability. And there's uninhabitability, that's a kind of a broad term. You'd be surprised at what, in this world of landlord tenant law, there's a lot of stuff that happens, and I think you'd be amazed. Maybe you wouldn't be amazed. The landlord cannot interfere with tenants' use of quiet and tenants' use and quiet and enjoyment of the property either. The tenant's obligations is to pay rent when due according to the contract, to give a minimum 30-day notice for termination. They have to keep the premises occupied, clean, and sanitary. They're liable for negligence to others. They must dispose of all rubbish, garbage, and waste. They have to use the utilities properly, keep everything in operating condition. They can't interfere with other tenants' rights. They have to refrain from willfully or wantonly destroying and defacing or impairing the property. And they have to occupy and use the premises only for the intended use and design. Interestingly enough, we don't see that all the time. We end up seeing situations where tenants come in and they don't have, maybe their definition of keeping a piece of property in good condition isn't your definition, isn't the landlord's definition. And so we end up with a property that's losing value, or we end up with a piece of property where the landlord has to come in and repair things. It can be quite expensive. Finding the right tenant is one of the biggest things you can do. Screening the tenant and making sure you get somebody in there who's responsible. Rent offset to repair and deduct. A tenant is allowed to notify a landlord of necessary repairs and allow adequate time for repairs to be made. If the landlord refuses, the tenant has the right to abandon the property, and they have to give the landlord a reason, but they can also spend up to 1 month's rent on repairs and send receipts for the repairs. They're allowed to do that twice in any 12-month period, but it can't be used for decorative purposes or habitability. We're talking about electrical issues, we're talking about major living issues, plumbing and things like that. Termination of a lease. Obviously, a lease will terminate when the lease term expires. Both parties can mutually agree to surrender the property. There can be a violation of terms and conditions where the landlord decides to terminate the lease or the tenant decides to do that. There can be, obviously, destruction of premises, which would terminate the lease, and then there's eviction, where there'd have to be notice given. There might be an unlawful detainer. There might be non-payment of rent, which is usually what happens, and then the illegal use of the premises. So there are good reasons to be able to terminate a lease and not have to let that tenant stay there for the entire duration. Sheriff serves the eviction, and we'll get into that in the unlawful detainer. A typical property manager controls operating expenses to maximize income. They obtain tenants and leases, and your property is sometimes as good as your property manager. They maintain the property and they oversee on-site resident management. Sometimes, if you have large units, you're going to have a property manager living on site. And then there's also a certification, as you know, called CPM, Certified Property Manager. Rent control. Los Angeles is big on rent control, I think more than Orange County and other areas. The intent is to make property available for rent at reasonable rates when there's a shortage of available space, and it may not be effective because artificially low rent may increase demand and discourage new construction, and I think we do experience that. Santa Monica has rent control that allows people to live there. The properties have, in terms of fair market value, an incredible value, but the landlords sometimes are strapped because they are forced to lease to specific types of tenants. Interestingly, I was just in New York, and there's rent control areas, rent control buildings, and an entire building, some of the buildings are dedicated to nothing but people on Broadway, actors and musicians, and they're able to live in these rent-controlled, it was fascinating, rent-control buildings forever. So they only have to pay like $400, $500. I don't know if it's that little, but it's like under $1,000 a month to be right off of like 42nd Street. And once you get in, you don't have to leave. Getting in is the problem. You have to wait for somebody to move or die. But it's really fascinating. It's an interesting phenomenon. This is a chart giving a general view of the eviction process. And I'm sorry it's small, but what we're dealing with is typically with serving on your left side a 3-day notice versus a 60-day notice. A 3-day notice is to pay rent or quit, and we'll go through this procedure. A notice to pay rent or quit. When a tenant doesn't pay the rent on time, what you would normally want to do is to pay a 3-day notice to rent or quit. The time that the period starts ticking is once the notice is served, the day after the notice is served. They're required to bring the rent up to date within that 3-day period, or the landlord or an attorney they hire can begin the eviction process. So if the 3rd day falls on a weekend, it defaults to a Monday. The notice has to be accurately stated. I've had to reserve notices because the rental amount's not correct, or the penny's not correct, the name is not correct. It's kind of ridiculous. But when you serve the 3-day notice, everything has to be exactly correct, or that tenant has a reason to be able to say that notice wasn't served properly. 3-day notice to pay rent or quit for cause. If the landlord can serve the tenant with a notice to vacate if the landlord believes the tenant is committing waste, is creating a nuisance on the premises, or using the property for an illegal purpose. It doesn't just have to do with the payment of rent. Waste is obviously destroying the property. Nuisance is dumping garbage and disturbing other tenants, and for an illegal purpose like selling drugs or anything illegal. A notice to quit for no cause. The 3-day notice to quit is really used mostly for lack of rental payment. But you have a 30-day notice to quit. If the tenant lived there for less than a year, you're going to serve a 30-day notice. You don't have to serve a 60-day notice. If a tenant lives in the property 1 year and 1 day or 366 days, you've got to serve a 60-day notice on the tenant. So even if you have a tenant that hasn't paid rent, and I have a situation right now where the tenant hasn't paid rent for 3 or 4 months, because they've been there over a year, they're going to get 2 months free because we have to serve a 60-day notice. We can't get them out. We serve the 3-day notice to pay rent or quit, but they didn't pay that, so we had to serve a 60-day notice, and then we have to wait 60 days before we can begin the unlawful detainer action. For a 60-day notice, let's see, if the property is subject to rent control. If the property is subject to rent control, the notice must state the just cause. You have to give a 90-day notice for Section 8 housing. A summons. This is the piece of paper that you will be filing with the court. It has to be served on the tenant, and it has to name the tenant correctly, and those or any other occupants. The service requirements, you can serve anybody who's 18 years or over. It doesn't have to be the party. If they're not at home, you can post on the door. It can be personal. Obviously, you're handing the complaint to them. It's substituted. You're going to serve it to somebody else, or you can post it on the door, and that serves as sufficient notice. The unlawful detainer complaint will not only include a summons, it'll include a complaint, and it'll include 3 or 4 different documents you have to file with the court. Once that is filed with the court and you serve the tenant, they will have 5 days to answer the complaint. To answer an unlawful detainer complaint, the tenant has the opportunity to deny the statements in the complaint or allege new facts, whether it's that the landlord didn't make the property habitable, or that they have a reason why they haven't paid rent. They have 5 days to file a written response or an answer, and the tenant cannot file a cross complaint or a cross claim. They typically, what we have is we have lawyers who will actually represent tenants to buy them extra time. So even if we have a just cause of action and we're filing a lawsuit for the right reasons, there are tenants or and attorneys whose entire goal isn't necessarily they know the tenant's going to leave, but they're buying time by filing an answer, or they're filing a demur, or they're filing another pleading to buy the tenant more time. If the tenant doesn't answer and they don't have representation, once that time goes by, the 5 days, we can request that the court default the tenant. So we'll file a request for entry of default with the court, and the default process is if the tenant doesn't respond, the landlord's complaint, they can ask the court for a default. The tenant loses a case without a trial. The landlord has a legal right to remove the tenant from the premises after a default judgment has been entered, and the tenant may ask the court for a motion to set aside the default based on mistaken inadvertence. That doesn't happen. You can't even file a bankruptcy There have been attempts to stop a tenant being evicted by filing a bankruptcy. They think it's similar to foreclosure. But you can actually get a motion to stay a bankruptcy because the landlord has a right to the premises. So a bankruptcy won't work. When a tenant defaults, the landlord has a right not only to all of the back rent, but all of the costs as well. It'll be based upon your lease agreement. I don't see that actually collected a whole lot. It depends on the situation. I had a client in Palm Springs who rented a beautiful piece of property to 2 tenants, and he was a realtor, believe it or not. He knew the system, and he didn't pay for probably over a year. He would make periodic payments and then not pay. So we finally evicted him, and what ended up happening was he let us default him, and ended up scurrying out of there, leaving a baby grand piano and a bunch of other things. But the amount of money owed in back rent was well over $30,000. And we're not collecting on it. It's too hard to collect, and to try to garnish wages or try to get a hold of money from a person, it's really difficult. That's one of the reasons why tenants tend to realize that. They know that. I mean, I'm not putting tenants down. Everybody needs tenants, but it's a really kind of unusual. It's a very weird situation when you have a landlord-tenant relationship, and there are tenants who know the system and know how to work the system. So we also have to be educated and know how to take care of our properties. A writ of possession is when the default's been entered, and the court will then enter what's called a writ of possession or sign a writ of possession. We can then go to the sheriff and we can lock the individual out. It's a UD judgment enforced by the writ. After the tenant loses, a landlord obtains the writ of possession and serves it on the tenant. Unless the landlord did not elect to declare a forfeiture of the agreement, the tenant has 5 days to pay. The tenant is locked out after 5 days of notice to vacate is given, and the sheriff executes the writ by serving a 5-day notice to vacate. One more thing I want to say, and I'm sorry I was only allowed 20 minutes. This is a very, very large topic, a very complex topic, and I think I've just touched the surface. What's interesting about an unlawful detainer, it's what we call in the legal field a summary process, which is supposed to mean it's supposed to happen really fast. It's not like a regular lawsuit where you're dealing with 3, 6, 9 months of, usually a lawsuit 6 months and a year, 2 years. A summary process usually we try to get it done within 20 to 30 days. I don't experience that usually in my unlawful detainers. I usually have to live this out for about 2 months. And a part of it's because the court system's so backed up that the court sometimes doesn't get our paperwork very fast. And then on top of that, the sheriff can't get out to serve. So it's not always the tenant. It's sometimes the court system. That's it. I want to thank you very much. We are going to become Kayser Payhor in about a month. So I have a new associate, a new partner who's going to be doing all the unlawful detainer, bankruptcy, and real estate matters. And we have some flyers somewhere, and if you would like one, we'll give one to you. Thank you very much.